King Charles has named his youngest brother, Prince Edward, the Duke of Edinburgh, a title held, of course, by his late father, Prince Philip, for more than 70 years. It had been the late Prince's wish for Prince Edward to be granted the dukedom after his death.
It's been a bit of a shock. However much one tries to prepare oneself for something like this, it's still a dreadful shock, and we're still trying to come to terms with that. And it's very, very sad.
The British royal family has survived abdications, affairs, divorces, and tabloid chaos that would have destroyed any other dynasty. But nothing, not Edward VIII, not Diana's death, not Harry and Meghan's exit, has rattled the palace quite like what is unfolding right now. This time it isn't a rogue prince or a disgruntled duchess. This time the threat is something the palace never learned to fight. Lawyers. Very serious lawyers, with very serious documents, arguing that King Charles III has been holding assets that legally do not belong to him. And the part keeping palace insiders awake at night? Those lawyers aren't working for Harry or Andrew. They're working for the one royal the institution always assumed would never cause trouble. The quiet one. The careful one. The son who showed up, kept his head down, and never once made it about himself. Prince Edward, Duke of Edinburgh, the youngest son of Queen Elizabeth II. Edward's legal team has formally confirmed in writing that specific entitlements worth potentially tens of millions of pounds, tied directly to one of the most historically significant titles in the British peerage, were legally his from the moment the dukedom was granted by his mother. Entitlements that King Charles, in the months following the Queen's death, appears to have quietly absorbed into the Crown's portfolio as though they simply didn't exist. The palace was not expecting this, and they are not handling it well. By the time we're done here, you'll understand why this may be the most consequential inheritance dispute in living memory, and why it could permanently change how royal property and titles are understood under English law. The man nobody saw coming. Before we can understand the legal earthquake, we have to understand the man standing at the epicenter of it. Because Prince Edward, Earl of Wessex, for most of his adult life and now Duke of Edinburgh, has built his entire public identity around one very deliberate characteristic. He is forgettable. Intentionally, almost aggressively forgettable. Think about it. When you picture the royal family's great controversies, Edward's name does not immediately come to mind, does it? When you think of abdications, you think of Edward VIII. When you think of affairs and divorce, you think of Charles and Diana. When you think of scandal on an international scale, you think of Andrew and the catastrophic fallout from his association with Jeffrey Epstein. When you think of open warfare with the institution itself, you think of Harry and Meghan dismantling decades of palace mythology from a studio in Montecito. Edward barely registers in any of those conversations. He left the Royal Marines training program in 1987 after falling short of completion, a story the press enjoyed at the time, and quietly pivoted into television production, establishing a modest company called Ardent Productions. He married Sophie Rhys-Jones in 1999, a ceremony that was notably warmer and more understated than the grand theatrical productions that surrounded his siblings' marriages. He carried out his royal duties. He smiled for photographs. He attended the engagements. He gave the speeches. He did not sell his story. He did not sit for revelatory interviews. He did not accumulate enemies or mistresses or headlines. For decades, the most interesting thing the press could say about Edward was that there was nothing particularly interesting to say about him. Ask yourself this. Before today, could you have recalled a single headline involving Prince Edward that did not simply reference his proximity to someone more famous? That invisibility was not an accident. It was a choice. And it was a choice that paid dividends in ways that nobody, not the press, not the palace, and certainly not King Charles III, fully appreciated. Because when you spend 30 years being overlooked, you get very good at watching, at listening, at understanding exactly how institutions work and exactly where the bodies are buried, legally speaking. Prince Edward was watching, and somewhere around late 2023, he decided it was time to act. The title that changed everything. To understand what Edward's lawyers found, you first need to understand the Dukedom of Edinburgh, not as a ceremonial label, but as a legal instrument, because that distinction is everything. The Dukedom of Edinburgh has one of the most peculiar and layered histories in British peerage law. It has been created, dissolved, lapsed, and reconstituted multiple times across the centuries. The most recent and relevant chapter begins in 1947, when King George VI, father of Queen Elizabeth II, granted the title to a young naval officer named Philip Mountbatten on the eve of his marriage to Princess Elizabeth. Now it would be easy to look at that gesture and see pure sentimentality, a father giving his new son-in-law a grand title to mark a grand occasion. And there was certainly sentiment involved, but that is not what the legal instrument said. The letters patent establishing the Dukedom of Edinburgh in 1947 were not dashed off in a moment of royal generosity. They were carefully constructed legal documents drawn up with the full weight of royal legal counsel behind them. They contained provisions, specific documented binding provisions about what the title carried, what rights, what entitlements, what charges and encumbrances attached to the dukedom itself, rather than to the individual who happened to hold it at any given moment. These documents were written to last. They were written by people who understood that titles of this magnitude exist not just in the present, but across generations. When Prince Philip died in April 2021, the dukedom fell into abeyance, a technical legal status that means the title exists, but is temporarily without a holder. This happens routinely when a title held by a consort reverts to the crown. The crown then decides whether to extinguish it, hold it, or re-granted it. What happened next was both touching and, it now emerges, legally significant in ways that the palace may have underestimated. Queen Elizabeth II, in the final years of her reign, made it known within royal circles that she intended to bestow the Edinburgh title on her youngest son, Edward. This was not a secret. It was discussed in royal circles, reported in the British press, understood as a matter of settled intention. The Queen wanted Edward to carry her late husband's title forward. She wanted someone she trusted to hold it with the dignity Philip had given it. On her Platinum Jubilee in June 2022, she made it official. Edward and his wife Sophie were formally styled as the Duke and Duchess of Edinburgh. It was understood as a deeply personal gesture, a mother honoring both her husband's memory and the son who had, quietly and without drama, always been there. But here is what the palace seems to have missed. When the Queen granted Edward that title, she was not simply pinning a new ribbon to his chest. She was, under the legal architecture of that 1947 instrument and the associated documents Philip had accumulated during his tenure as Duke, transferring a set of legal entitlements that attached to the title itself. Entitlements that, under a careful reading of English property law and the law of royal grants, did not simply dissolve on Philip's death and restart from zero when Edward received the title. They followed the dukedom. And when Edward's lawyers sat down in 2023 to conduct a meticulous review of every relevant document, the original letters patent, the trust instruments, the estate planning provisions associated with Philip's tenure, and the documents surrounding the formal re-granting of the title to Edward, what they found was extraordinary. What the documents actually say. Let us be specific, because specificity is where the power of this story lives. When Queen Elizabeth II died on September 8, 2022, two of the most celebrated estates in the royal portfolio did not pass to the crown in the way that most people assume royal property works. Buckingham Palace and Windsor Castle are crown properties. They are held by the monarch in right of the crown, meaning they belong to the institution, not to any individual. No sovereign can sell them, bequeath them, or mortgage them. They exist independently of who happens to be wearing the crown at any given moment. But Balmoral and Sandringham are categorically different. Balmoral Castle in Aberdeenshire was purchased outright by Prince Albert, Queen Victoria's consort, In 1852, it is private property. Sandringham House in Norfolk was acquired by Edward VII, then Prince of Wales, in 1862 as a private residence, paid for from his own income. Both estates have been held and managed as private property ever since, passed from sovereign to sovereign through private bequest rather than constitutional transfer. What that means legally is profound. Private property can be encumbered. It can be subject to documented provisions and charges. It can carry entitlements that survive the death of one owner and bind the next. Unlike Crown estate assets, which operate under a separate constitutional framework, private royal estates exist within the reach of ordinary English property law. And ordinary English property law does not make exceptions for kings. Queen Elizabeth's will is sealed, as are all royal wills, under a convention established after legal proceedings in 2021 sought to unseal the will of Prince Philip. The specific testamentary provisions of the Queen's will are not public knowledge, but the surrounding instruments, trust deeds, estate planning documents, provisions attached to specific titles, are not entirely invisible to legal scrutiny, particularly when a qualified legal team is specifically authorized by the title holder to examine them. What Edward's lawyers reportedly found within those associated instruments are provisions, clearly drafted, deliberately constructed provisions, granting the Duke of Edinburgh, whoever holds that title, specific entitlements relating to the use, income streams, and in at least one documented case, a partial reversionary interest in certain estate properties. Read that again. Not a courtesy. Not a suggestion. Not a vague aspiration that a kind monarch might choose to honor. A reversionary interest. A legal right that travels with the title and binds subsequent owners. And here is the critical phrase that Edward's lawyers have now apparently confirmed in writing. Those provisions were not voided by Philip's death. They were not extinguished when the title fell into abeyance. They survived. They reattached when the title was regranted to Edward. In the language of property law, the argument is that those provisions constitute a binding charge or encumbrance on the relevant interests, one that exists independently of who manages or occupies those estates on any given day, even if that person is the King of England. What Charles did, and what he apparently failed to check. This is where the story shifts from fascinating to genuinely explosive. In the months following the Queen's death in September 2022, King Charles III moved with characteristic efficiency to consolidate the royal portfolio under his authority. This was not unusual. Monarchs throughout history have done exactly this in the period immediately following succession, asserting control, restructuring management, ensuring that the sprawling apparatus of royal estates and financial interests operates smoothly under new leadership. Charles made significant decisions about Sandringham, changes to its management structure, adjustments to how certain income streams from its agricultural holdings and commercial operations were directed. He made decisions about Balmoral's long-term estate plan, including choices about forestry management, property development, and the future use of certain satellite properties on the estate. He consolidated certain historic income streams under the Duchy of Lancaster, the royal financial vehicle associated with the sovereign. These were serious decisions, high-value decisions involving assets worth somewhere between 50 million and several hundred million pounds by various analyst estimates. And according to those familiar with Edward's legal position, they were decisions made without fully stress-testing them against the specific provisions attached to the Edinburgh title, without, in short, pausing to ask a very simple and very important question. Does the new Duke of Edinburgh have a documented legal stake in any of this? The answer, Edward's lawyers now say, is yes. The palace's legal operation, however capable in most respects, appears to have operated on a set of assumptions about royal property management that the specific architecture of the Edinburgh dukedom did not support. Perhaps they assumed the provisions were ceremonial rather than enforceable. Perhaps they assumed that the regranting of the title to Edward was purely honorific, that Philip's specific entitlements had dissolved with him and were not transferred with the title. Perhaps they simply moved too fast, consolidating assets under royal authority at a pace that outstripped the legal due diligence required. Whatever the reason, by the time Edward's lawyers delivered their formal analysis in late 2023 or early 2024, King Charles had already made decisions that those lawyers now say were legally premature. Premature because they did not account for rights that had already vested in Edward the moment the Queen bestowed the dukedom upon him. The formal communication of that position to the palace, quietly delivered, professionally worded, legally devastating, landed like a stone in still water. The palace reacts. Silence, scrambling, and secret meetings. Now ask yourself this. When a powerful institution receives a legal challenge it believes to be entirely without merit, what does it do? It says so. Clearly. Publicly. It dismisses the claim and gets back to business. What does a powerful institution do when it receives a legal challenge it is not sure it can defeat? It goes very quiet. The palace went very quiet. The first phase of the palace's response was silence, a deliberate decision to keep this dispute in the realm of legal whisper, too complex for casual observers to track, too institutional for tabloid reporters to fully decode. Experienced royal observers noted something unusual in the palace communications operation around this period. The normal hyperactivity of the palace press office, the constant background briefings to trusted journalists, the subtle shaping of narratives before stories could gain momentum, was conspicuously absent on anything touching Edward's financial position or the management of certain royal estates. That is not how the palace behaves when it is confident. The second phase was back-channel negotiation. Sources have indicated that representatives of King Charles and Prince Edward have been engaged in a series of careful, lawyerly exchanges. Not warm family conversations about how to resolve a misunderstanding, but serious legal discussions about the meaning of documents, the scope of entitlements, and what accommodation might be appropriate given what those documents say. The third phase, and this is the detail that has most alarmed those watching this situation from the inside, is the palace conducting its own urgent legal due diligence. Quietly, behind closed doors, their own lawyers apparently re-examining instruments and provisions that the palace had previously assumed were settled matters. Institutions do not scramble for legal reassurance when they are confident. They do it when someone has just handed them a document that has made them uncertain. Meanwhile, those who watch the royal family closely have noted something harder to quantify, but impossible to ignore. A subtle cooling in the visible relationship between King Charles III and Prince Edward. Fewer joint public engagements, fewer of those easy brotherly moments that cameras used to catch between them. Edward and Sophie continue their royal duties with the same quiet professionalism they have always displayed. But the atmosphere, for those paying attention, has shifted. Something is being negotiated. Something significant. And everyone involved knows that the wrong word, spoken publicly, could have legal consequences. That is not how a family behaves when everything is fine. The real stakes, what we are actually talking about. Let us stop being abstract. Let us talk about the actual money, because the sums involved are not trivial. The Sandringham estate covers approximately 20,000 acres across the Norfolk countryside. The main house is one of the most recognizable royal residences in Britain. But the house itself is almost incidental to the economic reality of the estate. Sandringham encompasses a substantial portfolio of working farms, managed woodland, commercial agricultural operations, and diversified property holdings. It generates significant annual income from farming, game and wildlife management, and visitor attractions. Conservative estimates place the total value of the Sandringham estate at somewhere between £50 million and £200 million, depending on the methodology applied and the particular economic conditions of the assessment. The Balmoral estate in Aberdeenshire is even larger, approximately 50,000 acres of Scottish Highland, including the castle itself, numerous smaller residential properties, grouse moors that generate income from sporting leases, commercial forestry operations, and productive farmland. Its estimated value runs north of £100 million by most credible analyses. Both are private estates. Both were privately bequeathed by Queen Elizabeth II. Both carry sealed provisions that the public has never seen. And then there are the financial provisions that extend beyond bricks and land. Historical annuities tied to specific titles. Trust interests accumulated over decades. Income entitlements that, under the right legal instruments, can attach to a peerage title and follow it across generations. The Dukedom of Edinburgh, given its specific and deliberate reconstruction and the uniquely personal manner in which Queen Elizabeth chose to bestow it upon Edward, is precisely the kind of title to which such provisions could meaningfully and bindingly attach. We are not talking about a grace and favor apartment or a modest annual allowance. We are talking about entitlements potentially worth tens, possibly hundreds of millions of pounds. Entitlements that Charles III appears to have assumed were simply absorbed into the Crown's general portfolio upon the Queen's death. Entitlements that Edward's lawyers say were never the Crown's to absorb. And here is the question that should stop you in your tracks. If those entitlements are as legally solid as Edward's lawyers now say they are, if they are documented, defensible, and binding even upon the monarch, then what does it mean that Charles has been managing those assets for over 2 years as though they belonged to him? The argument Edward is not making, and the one he is. It is important to be absolutely clear about what Prince Edward's legal position does and does not involve. He is not claiming the throne. He is not challenging the order of succession. He is not positioning himself as a rival to Charles or attempting to relitigate the constitutional basis of the monarchy. This is not Harry and Meghan. There is no memoir in the pipeline. There is no documentary crew following Edward and Sophie around palatial homes while they discuss the institution's failings. Edward has not spoken publicly about any of this, and by all accounts he does not intend to. What his legal team is arguing is simultaneously more narrow and more explosive than any of that. They are arguing that specific provisions attached to the Dukedom of Edinburgh, as constituted by the 1947 letters patent and subsequent instruments, and as formally re-granted to Edward by Queen Elizabeth II in 2022, give the current Duke of Edinburgh legally enforceable rights over specific property interests and income streams. Rights that survive the death of the previous holder. Rights that vest in whoever holds the title, regardless of who that person is. Rights that a monarch cannot extinguish by administrative decision, however powerful that monarch may be, because they exist within the framework of English property law rather than royal prerogative. The legal concept at the heart of the argument is the question of whether those provisions constitute a binding charge or encumbrance on the relevant interests. In English property law, a charge or encumbrance is a legal obligation or right that attaches to a property or asset rather than to a person. It follows the property. It binds subsequent owners. It can be enforced against anyone who acquires the encumbered asset, including, in this case, the King of England. Edward's lawyers are saying, when the Queen transferred those entitlements to Edward as part of the formal re-granting of the dukedom, the binding nature of those provisions meant they could not simply be set aside. They could not be absorbed by the Crown without first acknowledging Edward's stake. They could not be treated as though they did not exist, because they exist in writing, in documents signed by serious lawyers, in instruments that have the full force of English law behind them. This is not an emotional argument about a son being cheated by his older brother. It is a legal argument about documents, about what was written, what was signed, and what that means. And the palace's inability to simply dismiss it, the urgent legal due diligence, the back-channel negotiations, the conspicuous communications silence, suggests that those inside the institution understand exactly how solid that argument is. Why this moment is bigger than one family. There is a version of this story that treats it purely as a royal soap opera, another chapter in the long, dramatic, endlessly watchable saga of Britain's most famous family failing to get along. And yes, the human dimensions of this are genuinely compelling. Two brothers, an inheritance, a mother's gift caught in the machinery of a powerful institution that may not have read the small print carefully enough. But this story is bigger than that, significantly bigger. We are living through a period of profound institutional pressure. Public trust in large institutions, governments, churches, financial systems, and yes, monarchies, has been eroding for decades and has accelerated sharply in recent years. The British monarchy has historically survived these pressures better than most, protected by a combination of public affection, ceremonial spectacle, and a very carefully maintained opacity about how the institution actually works on the inside. That opacity is now under attack from multiple directions. The Harry and Meghan departure broke something fundamental in the palace's relationship with the public. Not simply because of specific allegations, though some of those were serious, but because it demonstrated that the palace's famous institutional discipline could be bypassed, that members of the family could speak directly to the public, and that the public might listen and believe them, and decide that the palace's version of events was incomplete. The pandemic exposed the scale of royal wealth in new ways. Questions about the sovereign grant, about the Duchy of Cornwall's finances, about the management of private royal estates entered mainstream public conversation in ways they previously had not. And now, into that already destabilized landscape, steps Edward's legal team, armed not with personal grievances or television cameras, but with letters patent, estate instruments, and the methodical tools of English property law, making an argument that strikes at something the monarchy has always assumed about itself. That tradition is a legal defense. It is not. That the monarchy's internal decisions about asset management are beyond ordinary legal challenge. They are not. That even kings are bound by what documents say. They are. Constitutional scholars who have followed this situation with careful attention have noted that the questions it raises extend well beyond the Edinburgh dukedom specifically. They raise questions about the entire framework through which royal property is managed and transferred, about whether the legal instruments governing these arrangements have been maintained with sufficient rigor over the decades, about whether the palace's internal legal operation, which has historically operated with a degree of opacity that it justified through tradition and royal prerogative, is genuinely equipped to navigate the complexity of modern property law when that law is applied by determined opposing counsel. Edward's legal team, apparently, is exactly that. 3 possible futures, and what each one means. Where does this dispute go from here? There are 3 realistic trajectories, and each one carries consequences that extend far beyond the immediate parties. The first, and most probable, is a quiet settlement. This is how the British monarchy has always preferred to resolve uncomfortable truths. Behind closed doors, with carefully chosen words, in ways that allow the institution to maintain the appearance of seamless unity while making whatever internal adjustments reality requires. In this scenario, Edward's legal position is acknowledged in substance, if not in explicit public terms. Some form of accommodation is reached, a restructured income arrangement, a formal recognition of specific entitlements relating to certain estate interests, a quiet adjustment to how the management of the relevant assets is governed going forward. The public learns nothing concrete. The palace communications team releases a warm statement about the family's shared commitment to each other and to the crown. Edward and Sophie continue their royal duties. Charles continues to reign. And somewhere in the legal records of a very discreet law firm, there is documentation of an agreement that acknowledges, even in coded institutional language, that Charles's initial assumptions about those assets were not legally sound. Even this outcome, the quietest, most contained, most palace-friendly outcome, is significant, because even a private settlement is an acknowledgement. It means the legal argument was serious enough to resolve rather than dismiss. It means someone with the power of a king was confronted with a document that said, "not quite," and had to respond accordingly. The second possibility is formal legal proceedings. This is the genuinely explosive scenario, and while it is less likely than settlement, it cannot be dismissed. If negotiation breaks down, if positions harden, if the sums involved prove too large for informal resolution, if Edward's lawyers conclude that the legal architecture supports a formal challenge, this dispute could move into court. Royal family members have resorted to litigation before. It is rare, extraordinarily uncomfortable for everyone involved, and historically damaging to the monarchy's public standing. But it has happened. And a formal dispute in this case would be genuinely unprecedented in its modern context. It would require the application of ordinary English property law to the specific provisions of royal letters patent. It would require at least partial disclosure of instruments that the palace has always considered private. It would unfold in a legal system that does not, at least in theory, make constitutional exceptions for kings. And it would do so in full public view, with all the media attention that a legal dispute between the reigning monarch and his youngest brother would inevitably attract. The reputational consequences for the monarchy would be severe, which is precisely why settlement is so much more likely. But the existence of a credible legal threat, one serious enough that the palace has retained counsel and scrambled for legal clarity, is itself transformative. You do not settle disputes unless you believe the other side has a genuine case. The third possibility is the most consequential, and potentially the most lasting. That this situation, however it resolves privately, triggers a broader and long overdue review of how royal property rights are documented, administered, and legally protected. That the questions it raises become too significant to simply bury under another palace statement about family unity. That Parliament begins to pay attention. The management of private royal estates has operated with remarkable opacity for generations, justified on the grounds of tradition and the particular constitutional position of the monarchy. That opacity has largely been permitted because nobody with standing and resources to challenge it had previously done so effectively. Edward's legal team may have just demonstrated that it can be challenged, that the legal instruments governing these arrangements are subject to examination, that someone with the right title, the right documents, and the right lawyers can hold even a king accountable to what was written. If that case is established, even informally, even through quiet settlement, it becomes much harder for the palace to argue that scrutiny of royal property management is inappropriate, unprecedented, or unconstitutional. Parliamentary attention, once attracted, does not easily redirect itself. The quiet one who changed everything. Let us end where we began. Prince Edward has spent his entire adult life cultivating a public image of such studied ordinariness that even his greatest admirers would have struggled to predict this moment. He is the brother nobody wrote about, the royal nobody made movies about, the member of the family who, in a dynasty defined by excess and spectacle, seemed almost defiantly committed to doing nothing memorable. And yet here we are. Because while Charles was being Charles, and Andrew was generating catastrophe, and Harry was rewriting the rules of royal engagement from across the Atlantic, Edward was watching. He was reading. He was understanding, with the particular clarity that comes from years of quiet observation, exactly what his mother gave him when she granted him the dukedom of Edinburgh. She gave him a title, but she also gave him a legal instrument, a carefully constructed, deliberately drafted instrument that attached specific and enforceable rights to that title, rights that existed in documents, rights that survived her death, rights that followed the dukedom when it passed to Edward, rights that, it now appears, the most powerful man in Britain failed to account for when he made decisions about assets that those rights encumber. Edward's lawyers did their homework. They conducted a meticulous, months-long review of every relevant document. They read the letters patent. They examined the trust instruments. They traced the legal architecture of the Edinburgh dukedom back through decades of documentation. And then they wrote a letter. A formal, professional, legally devastating letter, confirming in writing what those documents say. The palace received that letter. The palace went quiet. The palace retained lawyers of its own. The palace began the careful, urgent, quiet work of figuring out what it actually faces. And somewhere in that process, somewhere between the formal communication and the back-channel negotiations and the scramble for legal clarity, something shifted in the atmosphere between two brothers who had always managed, despite everything, to get along. The quiet one has spoken. Not through cameras or book deals or bombshell interviews, through documents, through the patient application of English property law, through the kind of methodical, precisely targeted legal argument that cuts through tradition and ceremony and the assumption of royal prerogative to reveal a simple, uncomfortable truth. What the Queen gave Edward, she meant for him to have. And the institution that built its identity on the sanctity of tradition, on the seamless and dignified transfer of wealth and privilege across generations, now finds itself in the extraordinary position of being held accountable to exactly that tradition. Not by a rebel or an outsider or a tabloid newspaper, but by its own documents. History tends to remember the loud ones, the ones who made scenes, broke rules, captured cameras. But sometimes, the quiet ones change things more thoroughly. The palace has always assumed that Prince Edward was the one it did not need to worry about. It may have been wrong about that for a very long time. If this story has you asking questions, the palace would rather you did not ask. That is exactly the point. Share this video, because this conversation is just getting started. And tell me in the comments, do you think Charles will settle quietly, or is this heading somewhere none of us have seen yet?